Good morning and welcome to the 14th meeting of the Social Justice and Social Security Committee for 2025. We have apologies from Liz Smith and Mark Griffin, and I welcome Ros McCall to the meeting. So our first item of business for today is a decision to take agenda item 4 in private. Are we all agreed? Thank you. Our main item of business today is to continue taking oral evidence for our inquiry into financial considerations when leaving an abusive relationship. So I welcome to the meeting Alia Seyal, Member Access to Justice Committee, the Law Society of Scotland, and Colin McAllister, Chief Executive for the Scottish Legal Aid Board, and Cindy Morris, Head of Civil Finance, Scottish Legal Aid Board, who are all joining us in the room. And we have Sophie Berry, Solicitor from Govan Law Centre, who is joining us online. So thank you all for being with us today. And I'm going to start off with the questions. So in terms of the barriers that victims and survivors of domestic abuse face in meeting the eligibility criteria for legal aid, and are there any changes to the current rules which could help mitigate these? And I don't know if that will be Cindy or Colin covering that.
Good morning. I can certainly start.
Thank you.
Cindy is our technical expert, so can certainly go into more detail than I can. I think our general point would be that the financial eligibility rules can be quite complex. They vary as between civil legal aid, which is for court proceedings, and advice and assistance, which is for, as the name implies, advice and assistance, often in advance of an application for legal aid for court proceedings. And the rules are different between those two systems. The civil legal aid means test is the one that the committee is perhaps most interested in. It is itself quite complex. There are lots of regulations and guidance associated with those regulations about the sources of income and capital that we have to take into account, the allowances that are available, as well as sort of more general provisions in relation to discretion we have to either disregard certain forms of income or capital or to take outgoings into account. Because it's complex, we prepare guidance and issue that to the profession. We've been through a process over the last few years of reviewing all of our guidance and all the policies that are articulated through that guidance, trying to ensure that they are clear, transparent, that we can be held to account, and that those who are applying for legal aid know what they're looking at and know what we need from them. I think there are two things I would say. One is that the actual eligibility thresholds in the core parts of the test are contained in regulations which are introduced by the government and considered and passed by Parliament. The actual financial thresholds for legal aid haven't increased for some years now. And as a result, there's been a process of, I suppose, drift in the more of the population have either drifted out of eligibility because of general rising incomes, or they've drifted from free legal aid into contributory legal aid, because legal aid isn't always free, and there are between certain limits you pay a contribution. At the same time, the passporting arrangements in relation to universal credit have had an increasing impact, so there are more and more people who were previously on passporting benefits are on universal credit and are passported, but there are some who would have been on other legacy benefits which were not passported, but which now are by virtue of having been subsumed into universal credit. So it's a moving picture. Some people have benefited, some people have, as I say, drifted out. So we think that that whole system would do with a bit of a review, both in terms of looking at the options for uprating those thresholds and how the different changes that have happened over the last, what is actually 14 years, have impacted on the eligible population. At the same time, the way we apply the tests does have that room for discretion, particularly in terms of disregards and taking outgoings into account. what we have observed from the evidence that has been submitted to this committee and more generally some of the commentary over a number of years is that the way in which that discretion is applied isn't necessarily well understood. There are flexibilities in the system that can be applied in exactly the kind of circumstances that the committee is concerned about. But what we find is that quite often we're not either told about circumstances where we could apply our discretion or we're not asked to apply that discretion in individual cases. And we're not sure whether that's because the system is too complex and opaque or because either solicitors or those who are supporting those experiencing domestic abuse don't fully understand the ins and outs of the system or the flexibilities that we can apply, and they're maybe making assumptions about how the rules would apply, and therefore they're not availing themselves of the flexibilities that exist. So I think Cindy's team's experience is that we're not often asked in relation to things like trapped capital, for example. I don't know, Cindy, if you want to say any more about that.
Yeah, I would just reiterate what Colin says. I think in the last 12 months, you're lucky for half a dozen cases where we've been approached and asked to consider circumstances such as what we're looking to review here. I mean, as Colin touched on, we do have lots of discretion within our regulations, but we need to know about it. We need to have that communication first end to tell us what an applicant's circumstances are. Now, we know that that can be quite difficult for someone to sort of share, you know, how they've got into a certain situation, but if they don't tell us, then we don't know. So it's a kind of like share that information with us. We're not here to judge, but we will look to see within our rules and regulations whether we can get them into legal aid, because that's ideally what we're there to do. If someone is eligible, it's using the rules that we've got to disregard trapped capital, you know, coercive behaviour, all that kind of thing is something that we can consider, but we need to know that because we're not seeing it in the applications that are being submitted to us at this current time.
So just on that, because you've kind of answered my next question, right, which is fine, but just, so would there maybe be the option to maybe change the application in order to actually expand on the circumstances in which they're applying for it then? Or is that down to the solicitor?
I mean, the form that an applicant fills in at the moment is a pretty lengthy form. We're currently reviewing that. We were trying it online there to try and make it a bit easier for the application process to go through. What we do try and do is that the solicitor submits the application to SLAB, and then if it is a financial form too, we engage with the applicant direct and we ask them about their financial circumstances. We try not to go through the solicitor. We try and keep it in like a one-to-one contact with them. But I mean, there's always room to review that process and see if it can be made easier or more open and transparent. And as Colin touched on, we're currently reviewing our guidance as well, and we've recently updated stuff on our website about this type of situation. And again, we've made the key point that communication. Talk to us and tell us about it, and we'll review your case on an individual basis and see what we can do.
Sure, thanks. Do you want to come back in, Colin? Thanks.
If I may, I think one of the things that Cindy's team has observed is that once somebody is in that process and we have that dialogue, information can emerge that wasn't apparent on the face of the form. That can often happen fairly late on in the process. So once we've done an assessment and communicated the outcome, particularly if we've assessed a contribution, it will be the notification that a contribution is payable that might prompt the applicant to say, well, I don't have access to those resources, I can't pay that contribution. And that enables us to then have that further dialogue with them, uncover the circumstances, and then take that into account and revisit the assessment. I think the issue might be that some people might not get that far. So if at the outset they think the rules are going to work a particular way, they might not even get to the point of making the application because they might assume that they're not going to get legal aid or they're not going to get free legal aid, and that might put them off. So I think as well as all the work that we can do as part of our process there's an element there which is about training and awareness. And I mean, we do that regularly in any event. We go out and we work with firms of solicitors to explain the operation of the legal aid system. And as Cindy said, we're reviewing the guidance and we publish that guidance and issue those as updates to the profession. But I think there's maybe scope for a bit more of that. I think, as I say, the evidence suggests that there are maybe more widespread issues than we had perhaps anticipated. So we maybe need to redouble our efforts and maybe work with the society and other training providers to make sure that solicitors avail themselves of the training that we can provide.
Okay, that's really, really helpful. I think Marie wants to come in.
Just get us up to that. How is the legal aid system open to abuse, and how rigorous is the financial assessment? I mean, I've kind of heard some horror stories of some abusive partners trying to hide assets to actually enable them to qualify for legal aid. Is that something you've encountered?
It is a very thorough financial assessment review that we carry out. People have to provide us verification of all their bank accounts and their income. So we do that on a case-by-case basis, and it is a full assessment that's carried out. Where there obviously is an opponent in the case, we allow them to submit representations if they believe that there's been a failure to declare, a full true set of circumstances to us. And we have a team in SLAB who that's primarily what their job is, to investigate anything that is put to us.
Okay, thanks for that.
Okay, that's fine. I'm going to invite Ros McCall in now. Thanks.
Thank you, Convener. That's very interesting. We've heard evidence that the assets of a couple must be aggregated when assessing eligibility for legal aid. And what we've heard is a little bit about your process, but how does this affect the victims and survivors of domestic abuse, and is reform needed from their perspective? For
aggregation, it's not a clear cut that we aggregate resources of both parties. If they're no longer in a relationship or living together, then we don't aggregate the cost of the resources. Also, if we find situations where they may be living under the same roof, if they tell us that the applicant tells us they've got no access to income or capital, then again we've got the power to disregard the other party's resources. We don't have to aggregate. Okay. Again, it's a case-by-case basis. Tell us what your circumstances are, what your situation is, and again, we'll look at that and see whether it is appropriate or not appropriate to aggregate the resources together.
Okay, that's helpful. Thank you. Of course, Colin, yeah, please come in.
Another important proviso there. I mean, there are all those situations that Cindy has mentioned, but the other one is that if there's a contrary interest between the parties, we don't aggregate. So we wouldn't aggregate the applicant and the opponent's resources together. And in the sort of situations that the committee is considering, that will very often be the case. I think there were maybe, in some of the evidence, there were discussions around other case types, maybe housing-related cases, where it might be less clear that there's a contrary interest, and that's maybe where some of the flexibilities that Cindy mentioned might come in. But if somebody is, in effect, seeking a divorce or they're in a dispute around care of children, for example, then those resources won't be aggregated.
Okay, thank you. Going to the next question. In what ways might the proposals to introduce standardised personal allowances affect access to legal aid for those with no or limited access to their assets due to financial or economic abuse? Again, same questions to you guys. Unfortunately, I think you're the main ones that are answering there, but of course, if anybody else wants to answer from a different perspective, that would be great. But Colin, could I start with you?
Okay, so we consulted on a range of potential changes to the way we approach financial eligibility. So this is about our discretion, and rather than making individualised allowances for specific outgoings, which then require us to see evidence of those outgoings, we developed a proposal to instead provide a standardised allowance which would carry premiums in relation to, for example, disability or the family structure, etc. There are also statutory allowances in relation to childcare costs, work-related costs, housing costs that would not be included in this standardised allowance. We think that that would provide a far simpler process. It would be very clear and transparent from the outset. It would improve the predictability of the system. It would be easier for people to understand. They would just know that that would be applied to their case. It wouldn't depend on finding evidence of particular outgoings or remembering to tell us about all those individual items. Our modelling of it suggests that for a great majority of applicants it would be a benefit. Mm-hmm. So we would see more people more quickly being able to confirm qualification without a contribution, and for some of those who are currently assessed with a contribution, we think it would take greater account of their actual living costs and move some of those into non-contributory legal aid. In any system where you seek to standardise something that at the moment is highly, highly bespoke, and that's where the complexity comes in, there are going to be some people who will not benefit. But our modelling suggests that those are people who are far more likely to be at the higher income scale, who have got higher gross incomes, but maybe some higher outgoings, and it's that results in them having a reduced disposable income, and the standardised allowance is less likely to benefit them. But the vast majority of people would benefit from it. One of the issues we've identified in that is the way we treat debts. And so we're giving further consideration at the moment. It's one of the things that's been raised with us about how debts which are accrued in the course of a relationship might be taken into account over and above a standardised allowance, because our aim would be to remove the individualised assessment of debts, which we currently do, but we recognise that if debts have been run up effectively in somebody else's name as part of an abusive or coercive relationship, we may need to find an exception to enable us to take those into account over and above the standardised allowance.
Okay, that's very helpful. Thank you very much. And I'd be very interested in your views of the UK Government's proposals to ignore dispute assets and assets an applicant doesn't have access to in means testing for civil legal aid in England and Wales. Sorry, that wasn't easy to say. Should this be introduced in Scotland? What's your views on that?
Okay, I'll touch on the first bit and then pass over to Cindy. In terms of assets that are in dispute, the proposal in England and Wales was to, I think, remove the cap on the disregard for those assets. In Scotland, we disregard them already. It's called subject matter of dispute. Yeah. So assets which are the subject matter of the dispute are not taken into account as part of the financial assessment. There's no cap on that. So the full amount of those assets will be disregarded. If, as a result of the case, ownership of those assets changes hands, then that triggers what's called the clawback provisions. So property recovered and preserved, that's called the statutory charge in England and Wales, and that's mentioned in the UK Government's consultation on that as well. But essentially what the UK Government is talking about is moving to a position that mirrors our existing position.
Okay, thank you.
And if Colin touched on if there is clawback, then again, there's flexibility in how we would expect an applicant to repay that back to SLAB. Okay. We don't, for example, insist they sell their property if that's what they've gained, like title to the full matrimonial home. We don't ask them to sell that. We would try and enter into some sort of suitable repayment plan with them, and there's no interest accruing on any liability either for that.
Okay, thank you. That's very interesting. Thank you.
Okay, thank you. I don't know if any other witnesses want to come in based on what's been discussed so far, because I feel as though you've been ignored. Sorry. No, sorry.
Thanks very much. Just a few things to touch on what Colin's highlighted, I think. So first and foremost, we're talking about means assessment, and we're talking about advice and assistance and civil legal aid. And I think you can't look at them in isolation. You do have to look at them conjoined. Whilst there is passported benefits that allow you to be automatically entitled, but capital limits are also taken into account. And the capital limits are, if you don't have any dependents, are fairly low. It's just over £1,700. So I think the point that's been made about reviewing the assessment limits really does need to be taken into consideration. Equally, you could be on living wage and not have any dependents and not be entitled to advice and assistance. That does not mean that you can afford to be able to get to pay for legal advice. So I think the means assessment definitely needs to be reviewed both in relation to advice and assistance and civil legal aid. And Colin's outlined all the sort of complexities around it. So I think in terms of that simplification, that definitely needs to be considered. I think from the information that we have, a point that was highlighted, does it actually deter people from actually even getting to the stage of applying for civil legal aid? If they know that they have a contribution to pay, but they don't have the means to pay it, then you can understand why people might not decide to take any action. We've also talked about perhaps awareness and clarification of what means are taken into consideration in terms of both parties, and particularly if somebody's trying to get advice before they leave a relationship and they're unsure about how the joint assets or income is going to be taken into consideration, lack of awareness about what can be disregarded, lack of clarity about how discretion is applied. These are all factors that would deter somebody from getting early advice, let alone when they are in a crisis situation. I think the other thing just to highlight is in terms of clawback, again, there is discretion, but the complexities and the circumstances in which that discretion is applied perhaps does need to be reviewed, and to work with the society in terms of raising awareness and really perhaps understanding examples of where clawback has been requested but hasn't actually worked. And if a solicitor is rightly advising their client of the circumstances that are taken into consideration, again, it might not even get to that stage because people are discouraged from doing anything in the first place.
Okay, thank you. I don't know, Sophie, if you want to come in at all?
Yeah, I would just reassure it's just been said there, really. I mean, in terms of the assessing a client's income and assets, obviously that in cases of domestic abuse, they obviously often have income and assets that they don't have access to. And I appreciate what the Legal Aid Board was saying there, that they do have discretion not to take these things into account, but I do think that the main issue is often people thinking that they won't be entitled to it, or being advised by their solicitors that they won't either be entitled or that they'll be subject to a contribution. We support clients with housing and homelessness issues, and often in those cases the income and assets will be aggregated with the partner if they've not separated yet. And also obviously the clients that we see almost always needing family law advice as well, which we don't provide. So we see a lot of them coming to us to say that they've been turned away by solicitors because they've been told they might not be entitled to legal aid, or they might need to make a significant contribution that they can't afford to pay because they don't have access to the income or assets that they're purported to have. So those are the main issues that we see. I appreciate that there's discretion, but I think, as been said repeatedly, it's probably more an issue of awareness, not just amongst applicants, but amongst solicitors as well, who are advising whether a client may be entitled to legal aid.
Okay, thanks. Sorry.
Yeah. That's it. Thank you.
Okay, sorry, Sophie. I believe, Colin, you wanted to come back in there, yeah?
Yeah, thanks, Convener. Just to say, yeah, I agree with Sophie and Ali about that, the upfront perception perhaps being quite a strong factor. But in respect of Alia's point about the difference between advice and assistance and civil legal aid, yeah, absolutely. There is a difference in the means testing arrangements. The capital limits are low for advice and assistance. There's far more flexibility in respect of civil legal aid. The solicitor assesses advice and assistance. It is a simple test. They're not able to apply discretion in the way that we can, and they're not able to take outgoings into account in the way that we can, just because the statutory structures are different. And if somebody's seeking advice to consider their options, then eligibility for advice and assistance might then be seen as a barrier to then accessing civil legal aid. So the overall population eligibility for advice and assistance is much lower than it is for civil legal aid, and that's partly because we've got that quite long structure. There's a high upper limit for civil legal aid, which doesn't apply to advice and assistance. So those two eligibility regimes, in some respects, don't sit comfortably alongside each other, and one may act as a barrier to the other.
Okay, thanks very much. I'm now going to invite Jeremy in. Thank you.
Thank you, Convener, and good morning to the panel. Thank you all for coming. In the Law Society submission, you suggested that extending legal aid automatically to those with domestic abuse cases. I wonder if I can just explore that a wee bit. Firstly, how would that work in practice? So who would make the decision whether it was a domestic abuse case or if it was some other form of case? And secondly, and this is probably a more difficult question for you, Colin, have you any concept of how much that would cost the Legal Aid Board or ultimately the Scottish Government and ultimately the taxpayer, how much that would cost in regard to the amount of money?
There are already principles that exist, for example, in criminal legal aid.
Could you speak up slightly? I'm just slightly difficult hearing you, sorry.
Sure. There are already examples of automatic assessment, for example, in criminal legal aid. So there are examples to be able to learn from in terms of applying the same test for civil legal aid cases in relation to domestic abuse. So that is what we are asking be considered.
Okay, thank you.
I think there are a number of issues here that would need to be considered, and Ali is absolutely right that there are some other examples of automatic or access or no means tests. Those tend to apply in defined circumstances, for example, in relation to police station advice or for those who are appearing from police custody in the criminal courts. And the other example would be in relation to mental health tribunal proceedings in relation to compulsory treatment. So those tend to be situations where the state is seeking to put it bluntly, interfere in the fundamental rights and freedoms of the individual. So those tend to be the situations we see where automatic legal aid is provided. I think these circumstances are different, and I think Mr Balfour's question kind of hits the nail on the head in terms of how to determine which cases or which applicants would fall within those provisions, because very often it would be a very hotly contested part of an action. At the point of application for legal aid, we're not really in a position to judge what is being said to us in an application. As Cindy mentioned, when we receive an application for legal aid, we notify the opponent and they can make representations. And quite often we see people disputing things that have been said or alleged. And that's for the court to determine. And obviously the court's determination of the facts and the circumstances and the evidence that they will weigh isn't available at the outset of the case. So you get a bit of a chicken and egg. You can't get into court to establish the facts without the funding. But if determining the facts became a factor in whether or not the funding was available, then we'd have a little bit of an insurmountable barrier there. So I think there's a practical issue.
I wonder, when coming back to come to the cost in a moment. So in a previous century, when I was doing legal aid work, which was mostly civil, my understanding was the same as you, Colin. It was to get automatic legal aid was a fairly short procedure. It was a one-off year, and it was advice and assistance or whatever. Just going back to the Law Society, I mean, would you be suggesting that the legal aid should be for the whole case? So if that went to an appeal, would you be suggesting that the whole case, or are you suggesting the initial meeting with the client, the initial paperwork? Or I'm just wondering how long is the piece of string that you're suggesting in regard to domestic abuse cases?
I certainly think that at the onset it should not be a barrier. Colin rightly makes a point in terms of the disputed facts, but at the onset it shouldn't be a barrier, and the society can provide further information.
Okay, that'd be helpful. And then back to my $1 million question, but it might be slightly more than that. How much do you think, Colin, which could cost?
We haven't assessed that, and I wouldn't want to give you a number, because it would depend so much on how it was framed, and you know, the very question you ask about, you know, how extensive would that coverage be. I know the issue has been considered on a number of occasions previously. I think the Spice briefing touches on the 2018 consultation about that. Some members may also recall Rhoda Grant's bill in 2010-2011 that became the Domestic Abuse Scotland Act 2011. At introduction, there was a provision that would have made legal aid free in respect of protective orders, and some of these same issues were highlighted as to how one would tease out a protective order from a wider family action, for example, whether you would fund part of the action and not another part, whether you would result in two separate cases going forward to court with two separate applications for legal aid. So all of those factors would determine, I suppose, the scope of this measure, and therefore that would determine the cost. But as things stand, I don't think we would be able to really put a number on it. Obviously, government has previously highlighted the potential cost in a demand-led system as being one of the barriers to taking forward such a measure, but I couldn't put a number on it.
Thank you. I'll leave it there, Convener. Thank you.
Okay, thanks very much. I'm now going to invite Bob in briefly, and then Paul. Okay, thanks.
Yeah, as very briefly, I think it was Cindy Morris, sorry if I got this wrong, suggested that discretion was only applied and granted on 5 occasions in the last year. Sorry if I've got that number wrong, but if you could restate the number, that would be really helpful. But I suppose my question is, what work's been done to estimate how many times that discretion could have been applied for and potentially granted, and it hasn't been? I know there's no exact science around this, but an estimate or a ballpark figure or a feeling for how much lack of applications there are there where potentially it could be successful. Is there any more data you could just put on the record today so we see the extent of the challenge under the current criteria of discretion?
In answer to the first point, yes, I think it's count on one hand the number of cases that we've seen, where we have been asked to apply discretion in these types of circumstances. Second part, I don't know where to begin with that. We'd have to obviously do some analysing. I don't know if you've got a feel on that, Colin.
I don't, and I think that's the challenge, is that we only see what we see. So I think it's part of your question whether we've been asked to apply discretion and declined to do so, or is it that we haven't been asked?
Let me clarify, because obviously you can supply more information in writing rather than kind of springing this on you this morning. But I suppose what I'm asking is, everyone seems to agree there's a reluctance to apply for discretion, whether that's because of a lack of awareness or a lack of confidence it will be applied for. But do you know the extent of the problem? Have solicitors been surveyed? Does the Scottish Legal Aid Board have a feeling for how many times they think they would anticipate this should be being applied for? Because at the moment, no one's quantifying the extent of the problem. And if you don't have that today, please could you let the committee know? Because I think that would be important.
Well, no. Short answer is we don't know. The slightly longer answer is that I think it's other respondents' evidence that's highlighted it as an issue. So if you were to ask us how often it occurs, we would say it's not very often. The other witnesses, the other respondents have suggested that it's a widespread issue, but that's certainly not what we're seeing. And I'm in no way suggesting that that means it doesn't exist. It's just that we're not seeing it. And if we did see it, then I'm confident that we would be able to apply that discretion more regularly.
Okay, thank you.
Okay, thanks very much. I'm now going to invite Paul O'Kane in. Thanks.
Thanks very much, Convener, and good morning to the panel. We started to touch on some of these issues, but the committee is interested, I think, in the availability of solicitors in terms of doing this particular work and in terms of legal aid. So it would be useful, perhaps, just firstly to get a sense of, is there a lack of solicitors who are available to take on work in this area through legal aid, or is it a more general problem? I think there's been references in the Civil Justice Committee in terms of the lack of solicitors being generally available for legal aid work. So it would be useful just to get a particular comment on that.
Okay, your reference to the Civil Justice Committee is very pertinent, as you're aware that they're undertaking an inquiry at the moment into civil legal assistance. We're giving evidence, I think, in 3 weeks' time. I think the Law Society are giving evidence in a week or two as part of that inquiry, and supply has been one of the issues that has come up there. In our evidence to that committee, we talk about that, and we've also provided a research briefing to the committee in relation to a geographical analysis of supply. And again, the short answer is it's complicated. There's no one overarching picture that emerges from that analysis. What we've seen over a number of years is that while, compared to 10 years ago, the number of grants of civil legal aid is actually higher than it was. Under the surface, there's been lots of change there. So we've seen reducing numbers of grants in relation to family legal aid, but even within family legal aid, we've seen increasing grants in relation to residence, but reducing in relation to contact. So we're not sure why those differences exist. And in terms of supply, again, we're seeing different things happening in different areas of law and in different parts of the country over time. There's been a general reduction in the number of solicitors who are providing a legal aid service. What we're seeing is that those who are providing a legal aid service are doing so more often. The pattern is very much that there's a large number of solicitors who do legal aid infrequently and a small number who do it very regularly. The number who do it very regularly has not reduced in the same way as the number who do it occasionally, and those who do it regularly are doing it more regularly than they were previously. But again, that varies across the country. It varies between areas of law. There's been a growth in the number of solicitors undertaking guardianship work, for example. That's now the biggest part of the legal aid system. 20 years ago, it didn't exist. So there's been a significant shift there. So in terms of, is there a general problem with the number of solicitors? The data doesn't suggest that. Are there likely to be more specific issues? Yes. And those may be in some parts of the country, not necessarily rural areas. I think the assumption is that it's harder in rural areas, but what we're seeing is the biggest shifts have actually happened in Glasgow and Dundee. So some of the data is actually counterintuitive. It doesn't tally with people's perceptions, but that's why we think it's important to bring that evidence to bear in the discussion. In terms of the general supply picture, what's also difficult is that, if you like, past behaviour isn't necessarily an indication of future behaviour. Those who have provided legal aid are under no obligation to continue doing so, either generally or in relation to particular types of case or for particular applicants. Sometimes we do get calls. Cindy's team gets calls from people seeking solicitors. Sometimes it's unclear whether it's the specifics of the case. Sometimes it might be the specific applicant, and that might be because there's a conflict of interest or the solicitor's acted for a family member previously, or whether it's to do with a general unwillingness to do particular types of work, or whether it's a general capacity issue. So lots of different things happening. As I say, the submission that we made to the Civil Justice Committee goes into that in a bit more detail.
Thanks. I should probably have said at the outset that I'm a member of the Civil Justice Committee, as is Ms McNair, so you'll have to put up with questions from us in the coming weeks. But again, I think an important demonstration of the synergy that's here in terms of the two inquiries. Something that we looked at in that committee in terms of the regulation of legal services was the definition of solicitor and ensuring that people get access to appropriate legal advice. I mean, have you got any sense that, in particular, women who have been leaving a domestic abusive relationship and a violent relationship have been going to the right places in terms of getting the support? Obviously, we know the work that's done with partners like Women's Aid in order to direct people to the right places, but have there been any situations where people have been given poor advice, perhaps, or not been able to access a solicitor to have a legal recourse, I suppose?
I think, again, one of the challenges in the way the legal aid system is structured, and again, we said this in our submission, it doesn't look like a public service. It doesn't look like you would expect a public service to look. The way into it is opaque and confusing. So knowing who to go to is one of the challenges. There are many, many solicitors out there. Not all of them do legal aid, and not all of those who do legal aid do particular case types. So it may well be that sometimes when we hear about people who've phoned round 50 solicitors, 40 of those may have been absolutely not in the right ballpark, which is a challenge because nobody's to know that. And that's partly why I think you're referring to our work with Scottish Women's Aid through the Civil Legal Assistance Office. We've got a better insight into who is doing what types of work, and therefore we can target referrals more effectively, and we've had a 2/3 success rate in referring clients on there. So that work with other support organisations can certainly help get people to at least the right people. Whether or not they take the case is still subject to a whole range of considerations in that particular moment.
Obviously, we've referred to the committee work that's being done in terms of reviewing legal aid and looking at the structure. The government also have committed to a review of the fees, as I think we started to cover in our conversation this morning, but also a wider review of the legal aid system. I suppose the two questions here. One is about the pace of change and the pace of these inquiries. Do you think that that's quick enough? And secondly, what are the sort of broad issues you would want to see captured in any reform of the system? I appreciate that's a big question, but it would be useful, I think, maybe to get a sense of everyone's view on that. But I'm happy to start with Colin, just because, if that's okay, and then give some time to think.
Okay, I mean, there's lots that we think could be done to simplify the system, to make it clearer and easier to understand for the public and indeed for solicitors and indeed for ourselves. It's a complex system to administer. But I think part of the thrust of our submission to the Civil Justice Committee is that, yes, we can simplify the case-by-case legal aid system, but many of the challenges that are highlighted, both in evidence to this committee and evidence to the Civil Justice Committee, and more generally in recent press coverage, for example, are to do with a system which is built on post-war models and has not really evolved. So when you talk about the pace of change, it's a kind of 70-year, 75-year change process we might look at there. Our view is that the system should be more strategic. There should be more flexible tools to enable the system to respond to shifts in demand, to be able to target resources at particular needs, at particular communities, at particular types of case or groups or localities, and that the tools that exist in the current system, the demand-led part of the system, are pretty blunt in that respect. We've talked about eligibility today. You mentioned fees. Those are fairly blunt tools in terms of managing a demand-led service and in terms of prioritising resources. So it's very difficult to direct resources towards particular areas of need. And changing eligibility opens the possibility that people might access a service, but it doesn't guarantee them a service. Similarly, increasing fees might, in a general sense, make legal aid more attractive to more solicitors, but it doesn't mean that you would be able to say, yes, there will be a solicitor who will undertake domestic abuse-related work in Perth. If that's where your problem is, maybe the system should be able to say, we need to fund a solicitor in that area to work with Women's Aid or work with other support organisations or to deliver that specific service in that specific place. And that's not what the legal aid system is designed to do at present. And we think that's why it needs to be redesigned almost from the bottom up. And that would need primary legislation because within the current primary legislation, the scope for doing that is very limited indeed.
Thanks. Sam?
Thank you very much. I think, firstly, Colin highlights the number of practitioners, and I think the Society has been making submissions about the numbers that are reducing. And if we are observing that there isn't a reduction in the overall number of solicitors that are undertaking legal aid work, but there is a reduction in those that are practising in family law, I think we need to understand what the reasons for that are. I think from our position, The complexities have already been talked about. There are administrative burdens, and solicitors are choosing not to undertake this area of work, and I think that needs to be understood. We talked about earlier in terms of sort of automatic grants and where those automatic grants might be more pertinent, for example, in protective orders. I think when you're talking about wider reform, that needs to be taken into consideration. I think the next committee meeting that is looking at civil legal aid will look at some of the suggestions around wider reform, but particular to this committee's remit, I think these are the things that really need to be understood as to why there is a disparity in terms of solicitors that are now choosing not to do family law as an area of practice, whereas previously that wasn't the case.
Okay. I wonder if Sophie Berry has anything to add, particularly from, I suppose, a law centre's point of view on some of those points?
Yes, I do. One of the things that came up there was in terms of the reduced number of solicitors available for family law, but especially, I think, domestic abuse cases. Whether there are fewer or not, I think it's particularly pressing that there are legal aid lawyers available for domestic abuse cases because of all the reasons that we've discussed. And I think it's the level of funding is obviously one of the critical things, and there just isn't, the legal aid system doesn't allow for certain work that is necessary when you're trying to provide a trauma-informed service to victims of domestic abuse. And there's so many additional costs in providing more time and potentially in unsuccessful meetings with clients and travel costs for vulnerable clients that just can't be claimed back through the legal aid system. I think that's one of the things that makes it so pressing that in cases of domestic abuse that the funding is tackled. And as has been said, automatic funding for protective orders seems to be quite an obvious step in the right direction, and I think it can be separated quite clearly from other cases, civil cases, in that it's not a dispute between two parties. When you're looking for a civil protective order, it's an emergency situation. It's never the fault of the person applying for the order, so I think it's quite distinct from other civil cases to justify it being automatically funded. I'm trying to remember if there's anything else I wanted to raise.
It's okay.
I think that was all I wanted to mention. Thank you.
Any further points? No. I'm very grateful, Convener. I think that's very useful.
Okay, thanks very much. I'm now going to invite Jeremy Balfour in. Thanks.
Yeah, thank you. Can I just, I may have missed this column, so my apologies. Can I just seek clarification? You said there's been no reduction in the number of people, solicitors doing legal aid. Is that in total, as in criminal, civil, altogether? Have the numbers fallen in regard to civil and particularly family law?
No, sorry if I wasn't clear. There's been no reduction in the number of grants of legal aid over that 10-year period. There has been a reduction in the number of solicitors acting in those cases. Okay. And the reduction has occurred across civil, criminal and children's legal aid. So, as I say, there are fewer solicitors doing the work. Those who are doing the work are doing more of it. I mean, I suppose that's an arithmetic certainty. If there's the same number of cases but fewer people doing it, then the average is increasing. But when you look at the distribution there, the biggest reductions have been in the number of solicitors who did small amounts of work. There's been more stability or a smaller reduction in the number of solicitors who have been doing more legal aid work.
Okay. I mean, perhaps my colleagues are too nice to ask this question, but can I ask for our side, is that simply because it doesn't pay enough money? And so solicitors are choosing not to do particularly family civil legal aid work because they're not getting what they think is enough return for it?
Yes. Yep. Sophie highlights the amount of work that you need to do and the amount of work that you are paid to do. And there is a disparity between that.
And have you done any work, looked at what type of firm or firms are no longer doing maybe little civil legal work? Is it the sole practitioner? Is it the middle-sized firm? Have Velocity done any work, or legal aid done on what type of firms are now doing this civil legal aid work, say, compared to 20, 30 years ago?
I personally am not aware of the information, but I can certainly put it to the Society to ask.
We've done some analysis there. We've got limited access to information about firms beyond their legal aid activity, so we don't know what else they're doing. It's easier for us to analyse criminal supply because the majority of firms are more likely to be specialists in criminal work. And I suppose one of the points to make is that for legal aid work generally, and criminal work particularly, it is small firms. There are very few large providers of legal aid services. So I think the last time we checked, the average number of active practitioners for firms which are active in criminal work is around about 2. So 2 active practitioners per firm is the average, and that has been pretty consistent over 10, 15 years. It always was, and it still is the case that legal aid is concentrated in small firms.
Okay, that's helpful. I know the Legal Aid Board fund Edinburgh Women's Aid project, which is funded by yourselves, which provides quick access to specialist legal advice on family-related law issues. I wonder, going forward, if it's a model that could be replicated in other parts of the country, and could it be scaled up to cover, as I say, perhaps more rural parts and other parts out of Edinburgh?
Yeah. So there are 2 projects that we're running. There's the one where we fund a solicitor within Edinburgh Women's Aid. Yeah. And then there's the one that where the Civil Legal Assistance Office provides a referral service.
So it's number 1.
Right, okay. So it's a relatively new service. It's funded through, at the moment, until next March. So over the course of this year, we'll want to look at that more closely to see what impact it's having. It's a very focused project. So it's not undertaking general casework on behalf of the women who are accessing the service. It is very much providing that early advice and intervention, but if the case requires ongoing work, then it's referred out to other solicitors in private practice. So I think what we need to try and assess is what benefit that is providing, and it may be that it's that front-end barrier that it is effective in addressing. And if that is the key issue, then that may well be a model that one would want to replicate. If the issue remains finding solicitors who are experienced and knowledgeable and willing to take on domestic abuse-related cases more widely, then this project itself won't be a solution to that problem. So it's likely that there are lots of different issues and they need to be addressed in a multifaceted way. So I wouldn't say that this is a silver bullet, but it may well have potential to address one part of the problem.
That's really helpful. And just remind me, did you say it was going to come to, it's a year's project, did you say?
It's got one more year to run.
1 more year to run.
Yeah.
Okay, thank you. Question, my final question to all of you is, the Scottish Government has promised some reform of the legal aid system. In regard to particularly domestic abuse, what changes would you like to see brought forward in any reform of this? Maybe swap around and start with Sophie, if that's okay.
I think the changes that have been mentioned so far, automatic entitlement in domestic abuse cases would be the thing that we're primarily concerned with. Additional funding or uplifts for domestic abuse cases in cases where trauma-informed work is necessary. Obviously, as has been discussed, simplifying the means testing process, which has been discussed as well, would, especially in urgent cases, and perhaps the introduction of block fees, which has been raised as well, to simplify the process and reduce the administrative burden on applicants in these situations, I think are the main things that we would say need to be raised.
Thank you.
I would agree with a number of points that Sophie's made in relation to means assessment, automatic entitlement, simplifying the procedures and ensuring that solicitors have the means to be able to be paid for the work that they are undertaking.
Thank you.
I don't have a great deal to add. Simplification generally, maybe that enhanced training and awareness, the eligibility thresholds, particularly in relation to advice and assistance. And I think Sophie mentioned the block fee. That's a specific proposal. Again, we've included it in our submission to the Civil Justice Committee. Providing an extra block in relation to protective order work, we think would be of assistance there in recognising some of that work that Sophie's talked about is being needed in those cases. And then more generally, that ability for the system to respond in a strategic and targeted way to particular needs in particular places, potentially by funding posts instead of funding cases or funding particular activity.
Thank you, Camilla.
Thanks very much. I'm now going to invite Bob Dodison. Thank you.
Thanks, Convener. It's a two-part question. The first part has just been answered probably by Colin Lancaster and Sophie Berry, but let me just check. There seems to be a consensus that of the importance of civil protection orders, but there's issues about the cost for victims and the limitations of the legal aid system being able to show flexibility in relation to that. Can I just check that's the general consensus across all witnesses here this morning?
Sorry, in which particular respect?
So, civil protection orders, we've spoken about that, and there's drawbacks in relation to applying for those potential cost to victims and applying for them, and the limitations of the legal aid system and alleviating those costs. And I think I heard yourself, Colin, mention aspects of that, and Sophie Berry certainly did. So is there a kind of consensus amongst witnesses that that is something that has to be looked at? Again, rather than asking a specific question what the issues are, I think we'll probably establish that as a fact.
Well,
that's the view.
I think what we said at the outset was that there are flexibilities in the system that aren't perhaps being fully utilised, and if they were, that might address some of those issues. So whether that's a need for change or whether that's a need for increased awareness and using the flexibility that the system offers, either way.
And those same flexibilities exist for civil protection orders?
Yes, because that's it would be an application for civil legal aid that would be required in order for a case to be raised there.
That's helpful for my clarity. Sophie, could you actually briefly what you think the issues are in relation to applying for legal aid in relation to civil protection orders?
Sorry, I'm a little bit confused about the question.
So I've got, let me show clarity. What I'll do, I'll go back to the verbatim notes I've got, but I was trying to set it in context. And it says, when a victim has to apply for a civil protection order, drawbacks including the potential cost for the victim of doing so and the limitations of the legal aid system and alleviating those costs. So those are notes I've got from what we've established were called for evidence. I just wanted to make sure that all the witnesses agreed with that as a matter of fact, and whether there was anything, Sophie, you wanted to add to that before I go to my final question.
No, I don't think so. I think that's been covered, yeah.
Okay, thank you. So what I really want to ask about, I'll bring you back in, Sophie, because I think you mentioned it in Government Law Centre's written evidence. Part 1 of the Domestic Abuse Protection Scotland Act 2021 has a key role for the police enforcement, represent a viable alternative approach to the old system of civil protection orders, feel like with a key role for the police and enforcement. This hasn't been enacted as yet, and I know the Equalities and Human Rights Committee in this Parliament is also looking into why that hasn't been enacted, but the key aspect of it, as I'm understanding, is that it's not the victim survivor that applies for it and would not bear the cost, that Police Scotland could take that forward. So could you say a little bit more about that, Sophie, about the importance of that, and maybe what the barriers are to getting that implemented fully?
Yeah, well, obviously, I think the importance of that is that at the moment the process is obviously extremely complicated for people to get civil protection orders, not just with the financial barriers, but practically finding a solicitor, and it takes time. And it's the onus is obviously on the victim survivor to make the application and to instruct legal representatives. Whereas, if emergency protection orders were to be brought in, then when they are, hopefully, then in these critical situations, obviously the police then can step in and get a domestic abuse protection notice in place, and then hopefully a domestic abuse protection order. So it takes away all of that onus from the victim survivor of having to make the application themselves. And also it is an immediate, it should be able to be put in place much quicker. I appreciate, obviously, the police will need resources to do this, but I think it is essential really for victim survivors to have these protections in place as soon as possible. And yeah, I'm not sure what else there is to say about that, really.
No, Sophie, that's helpful, because you put on record that resource for police is a key issue in delivering it, but it should be a priority. So I think that's what we want to establish and put on record. Any other witnesses want to add in relation to the importance of Part 1 of the Domestic Abuse Protection Scotland Act being brought into force? Colin Lancaster.
I don't have any comment on the specifics of Part 1, but the general principle that the onus should be shifted from the individual, if you like, to the state to provide that protection is one that I think we've seen extend over a number of years. So part of the reason, and this is based on analysis that we previously undertook in discussions with Women's Aid and Justice Partners, part of the reason for the long-term reduction in the number of civil protection orders or applications for legal aid for civil protection orders has been a more proactive approach on the criminal justice system's part. So whether that's as part of special conditions of bail, providing the same sort of protection that a civil order might, or as part of sentencing in relation to those cases, non-harassment orders, etc., providing that same sort of protection, the onus has been shifted, and the requirement on the survivor to seek to protect themselves has shifted to the states. And as I say, I don't have any particular comment about the substantive aspects of Part 1, but my understanding is that is part of the aim of that provision, is to make it the state's responsibility to take that action rather than leaving it to the survivor to do that themselves. And the committee, of course, will reach out to government in relation to when that may or may not eventually come into force. Does anyone have any insight into when that might be implemented? No. Okay, thank you.
Okay, thanks. I'm now going to invite Marie McNair in. Thanks.
Thank you, Convener. Sophie, as you're aware, some abusive partners have been known to drag out legal cases just to maintain control over their ex-partners. What more needs to be done, and what safeguards do you think are needed to ensure the legal system is not used by ex-partners to perpetuate abuse?
Well, I think obviously it's most of the things that we've already covered, really, that would help to reduce the incidence of this. Firstly, availability of legal aid funding for victims of domestic abuse, so it can't be used as a means to deplete their resources. Also, more training and awareness in general for the legal practitioners on domestic abuse and economic abuse, and how legal proceedings can be used to perpetuate ongoing abuse after or during a relationship or after a relationship has ended. One other thing that I think is worth mentioning is that it would be my belief anyway that it's important not to try to force parties into mediation in these circumstances, because that again can be used as a means to continue the abusive behaviours of the perpetrator.
Thank you. I really appreciate your comments. Anybody else want to add anything? No. I'll hand back to Convener then. Cheers.
Just on just touching upon that as well. In terms of safeguards, particularly for SLAB, it was reported, I think, at the beginning of the week that there was a cyber attack on the legal aid in the UK. Just wondering what actions you're taking to ensure that the data that you hold are safe, particularly for domestic abuse cases.
Yeah, obviously we're very alert to the risks here, and we devote significant time and resource to ensuring that we've got robust protections. We undertake regular kind of penetration testing, and we've recently, just this week, been awarded Cyber Essentials Plus for the 4th year running, which is the general governmental standard for protection against cyber attack. We've been in touch with our colleagues in the Legal Aid Agency, who are understandably otherwise engaged right now, but we'll be seeking to work with them and the National Cyber Security Agency and the Scottish Government to try and understand, to the extent we can, whether there were any particular vulnerabilities that were exploited there, and to ensure that our systems and protections are robust.
Okay, well, that's reassuring and helpful, so thanks very much. So that actually concludes all our questions, unless any of our witnesses have got anything further to comment on. No? Okay, well, thanks very much for joining us today. And that concludes our public business for today, and we'll now move into private to consider the remaining items on the agenda. Thank you.